Do we want to address that or later, or Mr. Bill?
It's up to the council.
Why don't we do it during,
Can we have them come back to another meeting and talk about it?
we can put it on the agenda for next meeting, and we can let you know where we're at that time. That way we prepare ourselves where we are. But there's a rationale behind everything we do.
Well, if I might, though, it isn't really ready for it being on the agenda. The short answer, which I'll give quickly, the Secretary of State's position is held only by the Secretary of State. Every other participant in the lawsuit, the law itself allows for alternatives to district voting. The Secretary of State put out his administrative determination. I asked both his counsel, his legal counsel, and his staff to support that. They cannot. Their response was the original 2001 legislation was going to be followed up by legislation that narrowed it or fine-tuned it. That never happened. The law is clear that district voting is not the only way allowed in California. I'm familiar with Highland. They made a political decision to change, not a legal one. We've been talking to the Secretary of State's office. They are trying to go back to the original authors of the bill to get their take on it. The reason we are looking at cumulative voting rather than district elections in the city are entirely legal. You could carve the city into 5 districts. It would do absolutely nothing to cure the polarization, the vote disenfranchisement. All the demographers, the court, our legal opponents, everybody agrees. If you don't want to adopt a joke, feel free. You can do it legally. The council, though, doesn't like jokes. They wanted to do something of substance, something that had some respect for the voters. So, yes, we're looking at cumulative, and we're still addressing with the Secretary of State their disinterest. Their disinterest seems really to be driven by it would cost them to have to develop the algorithms to prove cumulative voting. It's an administrative concern they have, not a legal one. Neil Kelly, the Orange County Registrar of Voter, we've got an email from him. He says, I will do whatever the Secretary of State says. I can do cumulative, I cannot. I don't have a dog in this fight. You guys figure it out. The comment made about the city, if we went cumulative our own, is really incorrectly stated. If the Registrar of Voters will not participate, and if the City Council wanted to go cumulative, we could run our own election. That's where the cost would be. If, in fact, the Secretary of State relents and says, okay, we will do the work necessary to allow cumulative voting, then it would be under the general election through the Registrar of Voters. So I don't want anybody to think cumulative is solely on the city's dollar. It is not. It is only if the Secretary of State, I'll say, defies clear state law. And I note again, when I've asked them, shown them the statutes, they haven't been able to respond. Everything they've sent ignores the actual statute. Look at it. They do not address the California Voting Rights Act. They act upon general concepts. They said, well, you realize, city, the winner is the one who gets the most votes. Yeah, we all knew that. That's really not much of an answer to us. So we continue in good faith to deal with the Secretary of State. We don't want to have to turn this into a larger issue. A number of cities and special districts are watching us. Cumulative voting is seen in some contexts as the most legitimate way to enfranchise voters. And because an administrative office doesn't want to do it, doesn't make it the law. It just means they may have to be corrected. And that's what I've got.